Okay, Abusia, Yabemo Bibia Kwaba, Shronkoso, Abanama one political channel, POG Media, so make sure Safi, and as Waba, or like and subscribe and after sweat my share, Jumedino. I'm a from Sensa, to me, Aka, and please kindly click on the notification button so I'm a brand and the political update bed better channel is to be also. Onsa atumi aka na wahye na afin so asanso ache wadwene afie mbomra yensem nemne fansem dodo na embrew abusua legal practitioner bi atimi a petition EOCO say with immediate effect yenko nkwache former Chief Justice Gertrude Araba Torkono esan say according to legal practitioner what say Torkono Misuse public funds into our me prosecute Torkono na yetimi jail no esan say untimi fa oman sika endi sebi enkwasiasem enem wasem abusua news no ano ed ne papa Torkono EOCO for EOCO akwache no abusua me waste time plan momenko ne nkonkotie nsema EOCO so ne benansa na be convention say dwumadi unya like ya obe like share ma for from sensa into me enkebe medamasi
and welcome to. It's not ending anytime soon because the private legal practitioner James Addo has petitioned the Economic and Organized Crime Office for the arrest and prosecution of the former Chief Justice Gertrude Araba Torkono for misuse of public funds and willfully causing financial loss to the state. Now, exactly why are we going on this particular path, and why is he knocking on the doors of Economic and Organized Crime Office, that's EOCO, to look into this matter relating to the former Chief Justice? And here's the reason why. As we do know, it is the Daniel Ofori petition out of the three that the committee that was established to hear the petitions against the Chief Justice established the issue of stated misbehavior. In fact, there were 21 allegations of misbehavior captured in Daniel Ofori's petition and 4 allegations of incompetence. Now, here's what we do know. This is a summary of the number of stated acts of misbehavior, which is one of 3 grounds that the justice or a chief justice or a justice of superior court can be removed as enshrined in Article 1461 of the 1992 Constitution. This is it. It counted out 21 of them. The misappropriation of over 337,000 on foreign travels, arbitrarily reassigning cases between judges, dismissed judicial staff over minor offenses, unreasonably fast-tracked Appeño versus Speaker hearing, ordered national security to seize high court computers, and so many other things that were cited in this said petition by Daniel Ofori, which was the basis on which stated misbehavior was established against the former Chief Justice, and the recommendation by the 5-member committee to have her removed, which has been acted upon by the president. But then again, this private legal practitioner who has petitioned EOCO is coming under the law of causing financial loss to the state. And the petition for the arrest and prosecution of the former Chief Justice, the petitioner is asking EOCO to do a number of things. And his request is based on the following facts. That And this we're capturing directly from the petition that the petitioner sent to EOCO. We have exclusive copy of this petition by the petitioner to EOCO on the matter of his call for the arrest and prosecution of the former Chief Justice Gertrude Araba Torkono. This is exclusive to us here on Ghana Tonight, and this is it. He's basing his demand on the fact that her ladyship, Gertrude Araba Torkono, while serving as the Chief Justice and head of the Judicial Service of Ghana, willfully or negligently misapplied public funds when she used funds belonging to the Judicial Service to pay for her husband's travel with her to Tanzania in 2023, as well as paying him per diem for the duration of the private holiday trip, contrary to Section 96, 1, and that's 1C and D of the Public Financial Management Act 2016, Act 921. Also, that Her Ladyship Justice Gertrude Araba Esabasaki Torkono, while serving as the Chief Justice and head of the Judicial Service of Ghana, willfully or negligently misapplied public funds when she used funds belonging to the Judicial Service to pay for her daughter's travel with her to the United States of America, as well as paying her per diem for the entire duration of the private holiday trip, contrary to Section 96, 1C and D of the Public Financial Management Act 2016, Act 921. Also, that Her Ladyship Justice Gertrude Araba Sabasaki Torkono, while serving as the Chief Justice and head of the Judicial Service of Ghana, willfully caused financial loss to the state when she used funds belonging to the Judicial Service to pay for her husband's travel with her to Tanzania in 2023, plus the said per diem for the entire duration of that particular trip. And in fact, it goes on to ask quite a number of things as well from the EOCO, specific emphasis on the per diems and the trips by the former Chief Justice with her husband and her daughter. That's the basis for this petition for the arrest and prosecution of Gertrude Araba Esaba Torkono. That's what the petitioner essentially is asking of the Economic and Organized Crime Office, EOCO. And the petitioner, who has petitioned EOCO to arrest and prosecute the former Chief Justice, is joining us on Zoom right now. He's a private legal practitioner as well, James Addo. Counsel, good evening. Thank you for joining us here on Ghana Tonight.
Good evening, Alfred. Thanks for having me.
First off, I mean, when we got this exclusive detail and put it out there, the sentiment is that really, to what end? She's been removed as Chief Justice on the basis of the stated misbehavior, which includes this misappropriation that you reference, that 337,000. And so why are you piling up more trouble for her, going to EOCO to ask EOCO to arrest and prosecute her?
Well, very well. The first issue is that regardless of the outcome of the Constitutional Committee's proceedings, which led to her removal, the committee actually found as a fact that there was misappropriation of public funds or misapplication of public funds. And in the committee's words, from the letter that was sent to her secretly by His Excellency the President through his secretary, and which Her Ladyship decided to send to court, which has now become a public document, the committee stated that her behavior as the head of the judiciary in using those funds to pay for her husband and her daughter's private holiday was unlawful and against any law or policy. And under the Public Financial Management Act, which regulates all public sector institutions, any such conduct as this, which resulted in a loss to the state, is a crime which is punishable under the law separately from whatever has happened leading to her removal from office. So the fact remains that the monies that were spent on those trips were public funds which needs to be recovered for the state. So that is the basis of the petition which I've sent to the EOCO.
The cloud, or you're coming under the power of the law on causing financial loss to the state. Exactly why is that?
Yeah, so if you read those provisions of the law, it gives you the elements that needs to be satisfied before a public officer could be held under those laws. And my argument is that if you look at the findings of the committee, clearly the decision to use those funds for those purposes were willful. And for that matter, the misapplication itself was also willful. And so it fits perfectly under those two provisions of law. That is why I decided to go under those laws. For the EOCO to conduct its own investigation, and once they lay hands on the committee's full report, they'll get the justification as to why she needs to be brought in for under these two laws, and for that matter, held accountable for it.
I mean, to the extent that this matter, as you referenced, was captured in the petitions that were looked into by the committee. In fact, it is on the basis of one of them, right? This Daniel Ofori petition captured the misappropriation that you talk about, the references that you make, right? It is on the basis of this same Daniel Ofori petition that she was removed. I mean, is this a matter of double jeopardy, you would say?
No, it's not. It's not a matter of double jeopardy. What happened before the committee was essentially an administrative process, a disciplinary process. So what happens is that once the committee found adversely against her that an offense against the Public Financial Management Act has been committed, it means that there must be separate prosecution for those offenses and for her to be held accountable for those as well. Don't forget, she herself has accepted that those findings were correct. That is why in the new application that her ladyship filed in court challenging the the president's removal of her as a justice of the Superior Court, she is essentially accepting that the decision to remove her as Chief Justice was correct, as recommended by the committee on those grounds, which also means that once you accept the offense or that you accept the allegation that have been leveled against you as proven, and which then justified your removal as Chief Justice, then it means that the funds that you have misappropriated, which the committee described as unlawful, you would have to be held accountable for that by a court of competent jurisdiction. It is only at that point that she can make a claim. It is only after that if any subsequent prosecution comes up, that she can make a claim about double jeopardy. But for now, that claim cannot hold water.
I see. So the end objective of you asking EOCO to step into this matter is not for her to refund the money. You want her arrested and made to face the full rigors of the law, prosecuted for that matter.
In fact, we are asking for both, because the whole purpose is for the money that has been spent, if that money has not already been refunded to the state, to be refunded. But it does not also mean that the crime has not been committed. So she can be held separately for that as well. So my petition is basically asking for the Economic and Organized Crimes Commission office to take the first step of looking into this petition, procuring a copy of the committee's report, and once the EOCO comes to the decision that indeed the offense under the Public Financial Management Act has been committed, and also the Criminal Offences Act has been committed, then to proceed under the fiat of the Attorney General to haul her before court for the crime. If after that EOCO decides to recover the money, that is even better for us, because we want accountability, and that is what it is all about.
I see. Stay with me a bit, Mr. Addo. And I also have another private legal practitioner, that's Christian Mamhesi, joining us as well. Counsel, good evening. Thank you for joining us. And you heard the petitioner. It's also your learned colleague. It's a lawyer as well. It makes the point quite clearly that to the extent that there's been misappropriation of some funds in this matter, that was the basis for the removal of the Chief Justice, the established matter of stated misbehavior. It cannot be left unattended to. That the fact that she's been removed, that should end the matter. Monies have been misappropriated, and so it has to be refunded. she has to be arrested and prosecuted. That's the demand that he's making of EOCO. I mean, how does this strike you?
Good evening. Good evening to you, my brother, and good evening to viewers or listeners if they are also on the VFM as well. My preliminary comment, with all due respect, even though my learned colleague is definitely my colleague, I would say that it is fanciful. It is fanciful, and it attracts. It looks more dimful, as though to attract contemporary attention than what is duly necessary. And with all due respect and with humility, let me say that, yes, every person is entitled to file a petition. The purpose of this petition, just as has been explained, is for what it's intended to. Indeed, in law, it can be said that before the Article 146 committee sat, the Auditor General had conducted auditing in respect of the judicial service and had come to a certain conclusion, which conclusion never implicated the former Chief Justice of having committed a malfeasance or misappropriation of funds, which one would say that comes under the ambit of causing financial loss, under any of the ambits that the learned lawyer had petitioned under, because the primordial effect of it would be that. The second effect would now be that he would be seeking to rely his petition on that which the committee convicted the former Chief Justice on.
Yes, and is that not enough grounds for this petition to travel?
That is not enough.
The committee.
That is not enough.
Mm-hmm.
That is not enough, because indeed, if the lawyers for the former Chief Justice are seeking to wage a defense of it, indeed, the mere fact that had happened, that a committee had an adverse finding against the former Chief Justice, and that has occasioned her removal, does not necessarily mean that she has caused financial loss to the state.
Well,
and
to the extent that
a position of law.
I see.
That is a position of law that he has to prove, and he who alleges must prove. And it is not necessarily, it cannot necessarily be based on the fact that all that he is wishing to, or all that wishful thinking of his petition is based on that of the committee. It must necessarily be based on accounting evidence which can be extradited or elucidated from the judiciary, a way of auditing accounting.
Well, I want to find out
which
why
will be corroborated with that of the committee and Article 146.
Okay.
But he cannot necessarily base it on the fact that Article 146, because a number of the things that Article 146 happened, a number of the things that Article 146 committee did are in court. So to base a petition on an unsettled matter cannot necessarily be the waging of war of causing financial loss. Oh, come on.
Which aspect do you describe? No. Which aspect do you describe as unsettled? Is it the matter that she, based on this Daniel Ofori petition, which established the grounds of stated misbehavior, that was actually the basis for her removal, that the misappropriation of the over 337,000 CDs is not established as yet?
So now, yes. So.
Are you saying that has not been established as yet?
No, wait. So there is a stated, the committee and Article 146 jettisons to say that there is a stated misbehavior. Does the stated misbehavior metamorphosize to be causing financial loss? That is a question of law. And if you are advancing your claim as a complainant in a criminal matter.
Okay, Abushia, it's just winning some also our political hiring such as Gertrude Araba Torkono, former Chief Justice, Neho Aka, legal practitioner. Be at me a petition EOCO with immediate effect Yanko Nyankonkochi Torkono Nyanfanin Bijina Embrano. Esan say what cause a huge financial loss to the state until say ye de Torkono Ejina Embrano near prosecuting. So wait years Canada fine, but so won't you idea or sit me prosecuting a Gertrude Araba Torkono near Jilin Abushia, Medamo Bisi and Madame somebody penny me could someone I call so our political highway. So aha. POG Media and political news are make trends. Hanum say and on sabe can update in Madamasi.